Okay. Good morning, everyone, and thank you for attending this morning, our second Workplace Law and Culture seminar for this year. I also want to say hi to everyone on the webcast. We are finding that a lot of people are complaining these days about work. Whether it's the organisation, whether it's their colleagues, or whether it's their own treatment that they're receiving, everyone appears to have a complaint about something. And there's a lot of issues and rights over which complaints can be based, whether it's bullying or one's perception of what they believe is bullying, whether it's discrimination, whether it's flexibility requests, whether it's harassment or sexual harassment, whether it's safety, or whether it's to do with people's rights when it comes to disciplinary and performance management processes. Everything appears to be a tussle, and it feels like it is. And what we're hearing from everyone, from those that we deal with, is that it's taking an enormous amount of HR time and resources to manage these various complaints. And we're also seeing that these complaints are becoming intractable. They're becoming difficult to manage and to finalise, which is in the interests of everyone. And we're seeing that the difficulty is arising in part from complaint handling that could have been better. It's not just the issues of delay. It's not just the complainant being difficult or the person subject to the complaint being difficult. Often we are seeing that it's a misunderstanding or a misdiagnosing of the complaint, and there is along the way poor communication or a lack of communication. No doubt complaint handling is difficult and challenging. I don't envy any of you who are involved in it on a day-to-day basis. But with the new whistleblower laws, which I'm going to talk about today, it ain't getting easier. I think it's critical to get the tone right from the beginning. And that's the purpose of our talk today, is to talk about the front end of handling a complaint or a disclosure. Getting it right is critical, because if you don't get it right, the consequences can be significant. These are just some headlines in the last 6 months, which really give a good warning of responding negatively to a complaint, even though we would all love to perhaps say these things every now and then, can be costly. Barclays Bank, for example, was hit with a $15 million fine by regulators in New York after its chief executive decided it was going to try to discover the identity of the whistleblower. The whistleblower made a complaint about the appropriateness of the chief executive employing in a high-level role one of his close friends. The chief executive said he had to make those inquiries to protect the person, his close friend, from unfair publicity surrounding his appointment. Perhaps the chief executive wanted to protect scrutiny of his decision. But the regulators were unhappy with the approach taken to dealing with this particular whistleblower, using IT resources to track down their identity, and it resulted in a heavy fine. An American case that will have parallels under the new whistleblowing laws. So we can't discount the lesson there as an American problem. Cummins is an Australian case a few months ago, which involved a senior employee on some significant money with 34 years service in the organisation, who had made to management complaints about the HR manager and the quality of the HR manager's work. Now, the HR manager just happened to have the ear of management. So this senior employee who made a complaint about the HR manager, was chastised like an errant schoolboy by being placed on a PIP. Then there were misconduct allegations, and then he was dismissed. The court found that he was dismissed because he made a complaint. The outcome was a real kicker. Got his job back, could only be an Uber driver in the 2 years he wasn't employed, so he got full back pay, less the $15,000 he made with Uber, $1.1 million, and he's back in the job. Almost untouchable. So what we're really going to be talking about today is the key types of information that you're going to receive in your role. We're going to be talking about protected disclosures. This is a new beast that we're going to need to get across and manage well. We're going to talk about the workplace complaint, which is a growing area and the go-to complaint by employees aggrieved by their treatment at work. And then we're going to also talk about the grievance, and we've got to keep that in mind because that's another type of source of information, discontent that comes through the workplace that needs to be carefully managed. Now, for those in the state system, the New South Wales state system, the equivalent of protected disclosures is public interest disclosures that occur under the Public Interest Disclosures Act. I'll briefly reference that throughout our talk, but I do want to predominantly focus on protected disclosures under the new whistleblowing laws. So that probably leads into the agenda, which is I'm going to spend a bit of time talking about the new whistleblowing laws and their complexities. I'm going to talk about how the workplace right to complain has developed because that has become a significant problem for employers. I'm then going to talk about the front end, about the importance of triaging and planning how you manage a complaint or a disclosure properly from the beginning to be on the right track. And then we'll conclude by talking about some of the policies and systems you need to have in place for effective complaint handling. So to begin, to talk about the whistleblower provisions, a lot of the concepts I'm going to talk about here are similar for our state system colleagues and listeners to do with the Public Interest Disclosures Act, which talks about a public official being able to make a complaint to certain people, such as a principal officer, about corrupt conduct, maladministration, serious and substantial waste of public money. Much broader concept under the new federal protected disclosure laws, which start on 1 July. But for those in the state system, important to pay attention to this because the federal system applies not only to companies but constitutional corporations, and there will be some state entities that will fall into the definition of a constitutional corporation as we're slowly learning with the reach of the workplace bullying laws. So under these new laws, previously only a person who was a company officer, employee, contractor or supplier could make a disclosure. Now disclosures can be made by former company officers, employees, contractors and suppliers, and relatives and dependents of officers, employees, contractors and suppliers. So pillow talk and discontent now arms a partner to be able to make a complaint to a company about a disclosable matter. Now, a disclosable matter will be protected if the disclosure is made to particular and specified people. Those people are the officers of a company, so director and secretary, CEO, CFO, senior management, not supervisors and lower level management, but senior management can receive protected disclosures. It can also be the auditor of the company and any other person who is authorised by the company to receive these complaints. Now that's important because those people need to know this regime well. and not fall foul of any of the restrictions and regulations that relate to it, because they're going to be receiving protected disclosures. So they really do need to know this system and be trained well in it. Then, to get protection of the system, it needs to be about a disclosable matter. So in other words, what is being reported by an eligible whistleblower to an eligible recipient needs to be about a disclosable matter. And this is one of the most important areas of the new regime. Previously, it used to apply, well, and still today it applies until 1 July, to disclosures about contraventions of the Corporations Act. So very focused to the legislation. Now a disclosure can be made in respect of information over which the whistleblower has reasonable grounds to suspect that the information concerns misconduct or an improper state of affairs or circumstances in relation to the company. So it's no longer limited to the Corporations Act. It is far broader. And if the information concerns misconduct or an improper state of affairs or circumstances in relation to the company, that then attracts the protections of the new whistleblower regime. So what is misconduct or an improper state of affairs? Not defined. So we're going to have to wait and see how that plays out. Not helpful of Parliament. Things aren't always helpful from Parliament. What is misconduct? If we just look at it in the plain meaning, it means unacceptable or improper behaviour. That is very broad, and it is certainly broad enough to capture conduct whether or not it is in breach of any law. Whether or not it breaches any law, misconduct can be behaviour which is improper. That then sort of ties in and balances in with the obligation of an improper state of affairs or circumstances, which is also not defined. And improper meaning not conforming with accepted standards of behaviour. Again, a broad category, but it must have some limits. So I want to talk about the limits. What we know is this regime is about enabling a spotlight to be put on corporate wrongdoing, empowering people to speak up. So what we are not talking about is a forum in which aggrieved eligible whistleblowers can challenge any management decision and just say, oh, well, that management decision must be improper, must be misconduct because I don't agree with it because I would have done it a different way. The regime isn't about capturing those sort of complaints or protecting those sort of complaints. What it is talking about is dealing with corporate wrongdoing. And if we look at it through that prism, that is going to help us understand a little bit better what is misconduct and what is an improper state of affairs or circumstances. And what really helps us draw that conclusion is that what the legislation does do, though it says it does it without any limitations, is give us a flavour of what is that level of misconduct, what is that improper state of affairs, by referring to contraventions of the specific legislation that applies, but also going to conduct which is an offence against any law of the Commonwealth, which is punishable by imprisonment of 12 months or more, or that represents a danger to the public or financial system. So it is really talking about that higher level corporate wrongdoing. How far down that goes is what we're going to see through decisions of the courts. The other important aspect of these new laws is that it's removed the good faith requirement. So previously, a complaint needed to be made in good faith. So in other words, it couldn't be vexatious or frivolous or made for ulterior purposes. Parliament, in its wisdom, has decided that it doesn't matter whether the disclosure has other purposes or motives, because if there is some corporate wrongdoing, a light needs to be put on it. So the good faith requirement has been removed. In the state system, for example, they still have the fact that you can't make a public interest disclosure for the purposes of distracting from your disciplinary or performance management process, but that doesn't exist here. The threshold is that you as a whistleblower have reasonable grounds to believe there's some wrongdoing. And whatever your motives don't matter, if there's reasonable grounds, the organisation needs to deal with it in a constructive manner, because that leads to better corporations. Okay, so that's a big change. But thank goodness there's something that's not in. And that is an important exclusion, that if the disclosure of information concerns a personal work-related grievance, then it's not protected under the legislation. This is an important exclusion. What it relates to is a grievance about any matter in relation to the whistleblower's employment or former employment that has or tends to have implications for them personally and doesn't have significant implications for the company. Now, this is where we're going to have a little bit of a debate, because clearly, for example, a complaint about sexual harassment by an individual is a grievance that affects them personally and affects them only. But I'm not sure whether that's always going to be the case, because we can think of Miss Fraser-Kirk disclosing to the board of David Jones the alleged sexual harassment of her by the CEO of David Jones. That complaint, as we all know, had significant implications for David Jones. Is the nature of the personal work-related grievance itself capable to have significant implications? That's something that's going to, again, need to be tested by the courts. My advice is this. As organisations, you should err on the side of caution as to what is conduct that is misconduct or an improper state of affairs, but jealously protect what is a personal work-related grievance from being treated as protected under this legislation. The reason why I say that is that statistics show, at least in the state system where we've had public interest disclosures for a while, that close to 50% of those public interest disclosures are personal work-related grievances. A high number of it. And I suspect if statistics was done today, it would be even higher. That a lot of these complaints really do relate to the personal employment situation. So that does need to be protected. Why do you need to jealously protect that and scrutinise the complaints in that way? Because there are some very significant confidentiality requirements under these new laws. You cannot disclose confidential information in respect of a protected disclosure. So you receive it, you can't disclose it. What can't you disclose? The identity of the disclosure, of the person, of the whistleblower, and information that would lead or be likely to lead to their identification. So in small workplaces, for example, where it's a small team, giving even information about the disclosure might lead to the identification. And you can't do that. You can't disclose it. So that is significant. Who does the obligation apply to? You, if you receive the information and you're an eligible recipient, and to any person who obtains that information directly or indirectly. So this is a real strict regime for which there are significant penalties. So when does it not apply? Well, it doesn't apply if you disclose it to a prescribed regulator, such as ASIC or the police. Okay, so there are exemptions there because sometimes you got to have an obligation to report. It doesn't apply if the whistleblower gives you consent. Now that's important, and we will return to that throughout the talk. It also doesn't apply if what you disclose is not the identity and it's reasonably necessary for the purposes of investigating the matter, and you take all reasonable steps to reduce the risk that they're identified. So that is going to call into play quite a lot of action in terms of protecting the confidentiality. You know, are the whistleblowing reports stored on a separate IT system or in a secure drive and not accessible by anyone else? Being careful about how the existence of the disclosure and what you give out is reported, what obligations are put on people to not discuss it and disclose it, what other measures do you have in place so that way you control the risk that there is no inadvertent disclosure. There are provisions that deal with reprisals, and again, very, very significant provisions. Most of these you would all be familiar with, very similar to adverse action, very similar to victimisation provisions one would see in discrimination legislation, but certainly the types of conduct that can constitute victimisation are very, very broad, and it applies if you as the person who's taking the action against someone just believe or suspect that they may have made a protected disclosure. So you don't need to know that they've done it, it's just that you suspect that they've done it. And again, much like the Fair Work Act provisions, there's a reverse onus. So you've got to prove your innocence in these new provisions. So that, in a nutshell, is the protected disclosure provisions in the new whistleblowing legislation, which commences on 1 July. What one can immediately see from that is that it is a broad area that is being covered. And certainly it's a broad enough area that it would have been quite clearly a workplace complaint under the Fair Work legislation. But there will be disclosures that are made that are not protected that would then fall within the Fair Work Act and the workplace complaint provisions. So it's important to understand also the breadth of that jurisdiction to understand how best to manage and handle complaints that come across your desk. This is a broad category and the go-to category for aggrieved employees. What is a complaint hasn't been defined by the Fair Work legislation. But its plain meaning is a statement that something is unsatisfactory or unacceptable. So when I complain about there not being ice vovos in the kitchen, I am making a complaint about something that is unacceptable. Now I say that in jest, but this is what this legislation hasn't grappled with, is what is a complaint in relation to one's employment and whether or not that then attracts the protections in this system, because what we see in general protection claims is that people are really grabbing at anything they complained about to sort of say, well, I've now got a claim and you've got to pay me some money because you dismissed me. Because in 2006, I actually did complain about the ice vovos. We've had them here since, but in 2006 I complained. And that's why you've now dismissed me. So, can I say, certainly us respondent lawyers, we tried to limit this jurisdiction, but as we will see, the courts have fought against us, and this jurisdiction has some breadth. So initially, what the courts were saying is that a complaint must state a particular grievance or finding of fault. So in other words, it needed to be a specific complaint. And we had cases where, for example, a doctor would say, oh, look, I've got a report to you that I think my colleague's not doing a good job for these reasons, wasn't treated as a complaint, but just a report of information. And the courts were saying, well, that's not a complaint. That's not a complaint, it's a report, because it doesn't state a particular grievance or finding of fault. But then the courts moved and they said, well, you know, an implicit but clear complaint is sufficient. So they're sort of saying, we'll accept something less. Now, that arose in a case where a boss decided he was going to change working hours of certain staff, casual staff, by reducing the hours that they get. And the employee's response was to say, you're a racist, you're a liar for reducing my hours, I don't like you, you're terrible. And the court said, well, I know you dismissed this worker for calling you a racist and a liar, but they were actually making a complaint. That was a complaint about their working hours, even though it was all colour and little complaint. So we sort of got the movement moving away from some sort of boundary on what is a workplace complaint. And then we moved to the situation where the courts were saying it's not necessary that the worker says it's a complaint. It's not necessary that they tell you it's a complaint. It's just whether or not when you read that email, you would reasonably understand in the context that it was an expression of a grievance or a finding of fault. And that's where I started the talk today, was a little bit of a joke of saying, you know, well, everyone's got a complaint, everyone's got a whinge, but it's true. And you then got to work out, well, is this a workplace complaint within the meaning of the Fair Work Act, and how do we then deal with it and manage it? Now, quite often you can deal with those lower level complaints by just addressing it and responding to it and not letting it worry you. And that's what everyone does. However, it doesn't mean that they won't raise that later on if they are the subject of some disciplinary or adverse action. Now, the breadth of it really comes out in this case. Now, this case would probably fall within the protected disclosure provisions today. But Spiros Fatouros worked for Broadbeach Services, which I think was a building company from recollection, and he managed projects, and he was unhappy that the CEO wasn't paying the subcontractors in a timely manner. And he was upset because he had long-standing relationships with these contractors. So he sent an email to the advisors of the business after the CEO wouldn't pick up the timely payment of his subcontractors, saying, sadly, I don't believe the CEO is acting in the highest and best interests of the business. From a personal standpoint, if disciplinary action is to follow on and is the follow-on effect of my actions here, then so be it. So I think he knew what he was saying in the email was a little bit too strong and out of place, but so be it. I'll cop what happens. But please be assured my intent is purely driven by the interests of the business, its employees, customers and suppliers, all of whom we have obligations that are presently not being met. Now that was found to be a workplace complaint in relation to his employment, because even though it concerned whether subcontractors were being paid, I mean, there was no dispute he was being paid correctly, because it was his job to liaise with these people, then it related to his employment. So it fell within the workplace complaint provisions, and because he was sacked for sending that email, he was then awarded compensation in respect to that matter. So the breadth of the workplace complaint is that it doesn't actually need to directly concern your own employment. So this directly concerned subcontractors being paid, but because it was part of his job to deal with them, it had an indirect effect, and therefore it was a workplace complaint within the meaning of the Fair Work Act. The other type of information you'll get across your desk is, of course, a dispute or a grievance that arises under awards or enterprise agreements. That typically then tends to be an escalation process. So whereas a protected disclosure, you're going to have to get straight in there and investigate an action because you don't want them running off to Parliament or the media and making a disclosure. This is more of an escalation process before things get serious. All I really want to say about that is to really be clear that if you've got those instruments, be clear on what are the rules and regulations and the commitments and obligations you've made in them in terms of how things are managed. But what is important about these workplace complaints and the grievances compared to the protected disclosures is that more often than not, confidentiality isn't strict and it's a matter of good HR practice. So yes, if you get a workplace complaint about a manager, you can talk to the manager about that complaint. You can disclose to them, hey, I've received a complaint. So-and-so who you supervise has said you're nasty because you do X, Y, and Z, so we need to work on that. You can actually have a constructive discussion, not fearful that you're disclosing something for which you can be liable. That's important, and that's why is one of the reasons why I say protect jealously the personal workplace grievance exception, because you do have that flexibility in how you manage action and investigate workplace complaints as compared to protected disclosures. But you do need to be aware that because there's no strict confidentiality, it doesn't mean you can go and blab that someone's made a complaint to the workforce at large, because that in itself might be adverse action or victimisation. Okay, so to wrap up this section of the talk, the summary of the differences between those three types of information are up on that table. Now, these slides will be emailed to you afterwards, but what I really want to point out is the penalty provisions there, because the protected disclosures are a real kicker. They are huge penalties. And the little star I got, they can be higher. So there's twists and turns as to how the penalties are calculated and compensation and the like, but they are significant compared to the Fair Work Act provisions, which I think that 63 I may have discounted a little bit. Now, the complaint handling process, what I want to focus on is the first three areas of this, which is the triage process, the assessment process, and the consultation process. Now, this doesn't need to be three separate processes that take a week each to do, right? It can be something that you sit down and you do in a nice, concise time frame, but they are three separate thought processes that are important to how you effectively manage the complaint. The first hot tip and the key tip that I want to give, I spoke earlier about there being eligible recipients of protected disclosures and the importance of training them, because they're not allowed to talk about the confidential information, which is the identity and information that's likely to lead to an identification of the person who discloses it. And if they're not allowed to do that, for example, if you're a director of a company and you're only in there once a month, you're not going to be the one that's going to be managing it or investigating it. So you do need to say to the person who discloses it to you, thank you, we've got it. We've got all these great systems in place to protect you against victimisation, but I'm not the one that needs to investigate it. That will need to be HR, internal audit. So can I have your consent to pass this on to them? And they're really got to be able to get that and get that initially to then go and have that chat, to not breach the strict confidentiality provisions. We would be all too used to just thinking, oh, well, I just pass that on, but someone will make a complaint about that. And it may be because the person receiving it doesn't know the sensitivities, or disclosing it to that person from HR might be a problem from the discloser's point of view. There might be a conflict of interest. So it's important that the recipient has that initial chat in getting the disclosure, so that way it's done and handled correctly. One of the things that's going to need to occur up front is also to first assess, is it a protected disclosure? Is it a whistleblower complaint? Because that's going to tell you about all the rules, all the confidentiality obligations you need to comply with, whereas if it's not, you've got some flexibility. So what you're really doing is asking yourself those questions, which we've been through, and really getting down to the bottom and saying, does this concern a personal work-related grievance? If it does, then you know at the next stage you're going to have to really think about the confidentiality provisions and the obligations that apply. If it's not, you can sort of breathe a little bit easier. Because then you're asking yourself, okay, well, what other type of complaint is it? Is it a workplace complaint under the Fair Work Act that we've got to be aware of and deal with on the front foot? So that way we can show that we weren't motivated if there's a disciplinary process occurring by that complaint. Is it a complaint under work health safety legislation? There's a regime that applies there that you would need to follow. Or is it a grievance under an industrial instrumental policy? Again, you would treat that quite differently. Or is it just information? Is it none of that you can just then deal with in the ordinary business course? So I want to give a story where it's a matter I've dealt with recently where it went off the rails very early and it is now very difficult to recover. A particular manager has had a history of, and I say unreported, complaints about their conduct. So in other words, people have said things, but it's never been put as a formal complaint, but everyone knows this particular manager isn't the best communicator. A new employee comes along and decides to make a complaint about bullying, and this one is put in writing, it's clear, the new employee is wanting it to be actioned. Now, the employer says, let's treat this as a grievance because, you know, we don't want to upset the manager, but we do want things to be fixed up. And I won't criticise them for that because their intention was to look at training and mediation to have a safe work relationship. So let's actually deal with this constructively and let's get things to just work. And let's do this quickly and efficiently. Problem is, didn't really do a risk assessment up front as to whether or not that was the course. You know, the only path you're going on. There was really no critical thought to the sense of this particular manager who happens to run a particularly important unit has a history of complaints and the problem might be quite big. It might have significant implications for the organisation. It could be more significant than just as a grievance. So what does the manager do when they have this light discussion and about this light way in which they're dealing with it? Well, they take offence. How dare someone says I'm a bully? That's unbelievable. I've never had a complaint against me in all those years. And then the lawyers start writing letters. And the instinct there is to say, oh, well, the lawyers are writing, we've got to turn the heat down, so let's just keep emphasising that this is a grievance. This is a grievance. It's low level. You don't need to get worked up. So there was no reassessment of the situation or approach. And it's just reinforcing the course that's occurring, which I hope everyone can see probably wasn't the best approach in the end. At the end of the day, there was a significant complaint of bullying and the organisation knew that there were past concerns. This wasn't a small interpersonal conflict. This wasn't a once-off event. Certainly, if you couldn't resolve it by taking the action of training and mediation, then something else needed to occur. And what was actually occurring was there were more counter complaints now. More counter complaints. And the new employee is anxious, stressed, not at work, and nothing's really working. And nothing's really progressing. And what really went wrong here is that initially no one sat down and said, Houston, we have a problem. We have a problem. We have someone who is a potential bully, who we know may be a potential bully, and we're not dealing with it as a significant matter when a constructive approach didn't work. So there was no investigation set in place early on. There was no establishing of what the facts were. There was simply no measures to ensure safety moving forward. And that's where this process really becomes important. And they sort of all run in tandem with the triage and the next step that I'm going to be talking about. But what we've really got to do is we've got to assess. We've got to work out, do we need further information? Okay, so you get a complaint of bullying. Is there more we need to look at? Is there a history of bullying? We need to risk assess the situation. And then we need to come up with a plan. Certainly, initially, you've got to ask, do we have enough information in the disclosure? Now, I know a lot of the complaints are broad and they just say, I'm being bullied and harassed. Do you need more detail about the actual complaint? But do you also need more detail about who else knows about the behaviours? How much bigger is the problem from the disclosure's point of view? So get in there initially and start communication. Risk assessment, it's more than just assessing the risk to individuals. It's also the risk of confidentiality being breached. It's the risk of reprisals and reputational damage as well, impacts on the business, the workplace and the work group. You're also assessing what's the credibility of the disclosure. A lot of the disclosures don't have credibility, and part of that initial process is assessing that. And that will influence what steps you take as well. You've got to look at how serious is the situation and what's the risk of harm. Sometimes that can be hard for us to do in our bubble, where we're looking at it and all we're getting information from, I suppose, is the business unit, or in protected disclosures, you might not be getting a lot of information because you can't talk about it. That's where consultation and communication becomes quite important. And then you've got to look at what actions are available to address the risks. Something which everyone seems to avoid, and I really haven't worked out why, is a risk measure of training and education when you get a complaint. Certainly, someone who's been alleged to be a bully, even without making findings that they are, why can't you retrain them in your bullying process to be able to say, well, we got that complaint, it's an opportune time to do something about it, and you can say to the person who made the complaint, we're going to train everyone, and that's going to be part of making it safe for you to return to work whilst we're going through whatever process we need to go through. Everyone sort of seems, I think, to view that step as making a finding against the person accused, whereas in this interim period, what you're really doing is working out how you can get everything to just work. So you're not fighting off all these side issues, such as the complainant saying, I can't be at work because it's unsafe and you've done nothing about it. So I think that's quite important as part of that risk assessment process. Part of that process is also looking at, well, what are we going to need to do to actually action this, to investigate it? You need to think about whether you need to report the matter, particularly with protected disclosures, and even report it internally and get the consent to do so. You've got to start thinking about, well, how can we investigate the matter as well? If we've got these confidentiality obligations, what are the ways and means in which we can investigate, and identifying what they are and identifying if there are impediments to investigating or taking action because of confidentiality. That's quite important up front, because that then tells you what is the discussion you need to have with the person who is making the complaint or disclosure. What I do want to talk about is a very good example of handling complaints well. And this was just in the Australian Financial Review. KPMG received a whole lot of postcards which just said, "Are you aware of this man's behaviour to women? Please ask." And it was all about this particular partner and the way in which women are treated in the organisation. Now, very easy to say, well, no one's put their name to it. It's just general. It has no credibility. So we're going to do nothing about it. Postcard perfect handling. What KPMG did was they conducted a range of one-on-one and group interviews with their female staff. They didn't identify the partner or identify the issue, but they did ask if there were any factors or people that made working at the firm easy or difficult. So again, they're not identifying. It's a general, broad question, but designed to get information so that they can action what may or may not have been a problem on the postcards. They also looked at their data, which was their 360 degree feedback information, turnover data, exit interviews, engagement results, to work out if there was a problem. And what they worked out was that there was no problem. There was nothing there. But they received a dozen of these postcards, all alerting to potential issues. And it's important because under the whistleblower provisions, you can make anonymous disclosures. And you've got to action those disclosures, because if not, they can then be reported to the media or Parliament through an escalation process in the legislation. But that is a perfect way to manage the complaint. Not discounting it, but looking at the other sources of information to be able to assess credibility. I cannot emphasise enough the importance of consultation and communicating with the complainant. This is an area where things do fall down, because what people tend to get is just a standard letter, or a letter that says, we'll look into it and here's EAP, and there's not that regular update or engagement with the person who's made the complaint. Engaging with them also enables you to get the consents you need. It enables you to identify risks and to identify the measures you need to put in place to protect them and to be able to deal with the matter. If you follow that process and have that discussion about those matters with them, you might find that the interim period is shorter. You might find that the interim period is a whole lot more peaceful than having them not knowing what's happening, not comfortable with the process you're taking. And I'm not saying that they need to agree with the process you take, but at least that you've obtained their views on it and taken it into account. This is where a lot falls down and where things then become quite intractable and difficult. Action. I think everyone here knows I'm not a huge fan of investigations, but certainly one thing you would do with these complaints is potentially investigate the more serious ones, but there's a lot of other things you can do to be taking action. And that's what protected disclosure legislation is about, is that you get it and you take action. It doesn't say what action you need to take, but that you take action to address the alleged wrongdoing. And that's the same with the workplace complaint provisions. So there's lots of things you can do. You can do audit surveys, you can do surveillance to find out what's going on, you can take managerial action, and you can even do training and mediation. There's lots of other alternatives, and all of those other alternatives assist in a safe workplace where people can come forward and deal with things. Certainly, even if there is no substance to a protected disclosure, for example, you can still improve and learn from that disclosure. There may be systems improvements that can be made. Public companies and large proprietary companies, companies that have revenue greater than 25 million, more than 50 employees, will need to have a whistleblower policy that's got to contain all that information, including how the company will ensure fair treatment of employees. And that's going to require some thought as to what you say to your employees, those who may be subject to the complaint, those who make the complaint, as to how you're going to give them fair treatment and set that out in a policy. So you're going to need to put in systems and processes that talk about no victimisation, no reprisals, moving people around if it's a very significant matter, how that occurs, whether there's a right to reply to complaints and disclosures and the like. You're going to need to address that information in your policy to do that. Where I want to conclude before questions is that this is a difficult area, having a whistleblower policy that needs to interact with all your other policies. And boy, do you have a lot of them. Okay, you've got a code of conduct. You've got a sexual harassment policy. You've got a bullying policy, discrimination policy, and a whole lot of others. Some of those policies will cover topics that will fall within protected disclosures and that have a regime to manage and action them that might be different to what you've presently got in your code of conduct or your other policies. You need to think about the interaction, and you need to think about not giving the higher protections and restrictions in the protected disclosure regime to all your other policies that relate to a personal work-related grievance. Because what you'll be doing is creating a rod for your own back, setting yourself a higher standard in those other areas where that higher standard only needs to apply in respect of what is truly protected disclosures. You also don't want to inadvertently authorise that managers and supervisors can receive protected disclosures, because they're the ones that are probably going to breach confidentiality, because they're not going to be as skillfully trained as those higher up in the organisation that understand what 10.5 million means by way of a penalty. So there really does need to be some careful management with the interaction of those policies, because it's a real danger that you will be potentially authorising lower level people to receive those protected disclosures. But you do need to start getting those policies ready and in place, because they need to be ready for the new year if you're a public company or a large corporation. So with that, happy to take any questions. No at all? Confident? Excellent. Well, okay. Well, look, thank you everyone for attending. It's always great to see you all here. As I said, these slides will be emailed out, and if you certainly do have any questions, don't be afraid to approach any of us. Thank you.